Let's talk about a few of the concepts in Chapter 2 dealing with the court decisions. As a litigator, I dealt with court decisions all the time. I read them, I helped write the briefs that were submitted to the court, and then the court would use some of my language in their opinions. So to me it's second nature, but I know it can be kind of confusing for you guys, so let me see if I can help you. First, the text talks about judge-made law. Essentially, when our country was first beginning and we had judges and we really didn't have a whole lot of laws on the books, the judges were the ones who decided the cases on a case-by-case basis. So if somebody came and said they had a property dispute, the judge would decide it. Here's what happens. And that happened over time. And so we refer to that as the common law. That's where we got our basis of law originally, before we had all the government we have today and all the new laws that are passed. So when you hear the term common law, we're just talking about the laws that were basically judge-made through the cases on a case-by-case basis. The text then talks about precedent. And really what we're talking about here is once a judge made a decision, and usually there was an opinion, that just means it was written down, then that opinion is for everyone else to see. All the other judges, they can look it up. Anyone who's a plaintiff or defendant, their attorneys can look it up. And so that decision stands as a precedent for that particular case. Now, whether or not it is used in another case depends on whether it's from the same state, so that the judges in that same state would need to follow it as precedent. But essentially what they're trying to say is that precedent is when you have a court decision that stands as authority for deciding a similar question. So let's say that there's a property dispute in the state of Missouri, and it has to deal with land that's owned by the state, and there was a conflict. The judge makes a decision in that case. Now, 10 years later, another dispute that is similar, but it involves state property and a similar kind of conflict, facts would be a little bit different, then essentially that prior decision would serve as precedent. And so one side or the other in the new case can use that prior decision and say, hey, judge, you need to go back and look at this other decision. That's how this case should be decided. So that's what precedent means. And stare decisis is a Latin term that they've put in the book that basically says, let the decision stand, and that's another way to reference a precedent.